Hello, and thank you for joining us today. I am joined by friend and estate planning attorney Rebecca Goldfarb, who is with Goldfarb and Liu. She founded the firm with her partner Din Liu in 2008, and their specialty is estate planning, special needs trusts, and elder law. How did I do on that?
Pretty good. Thank you. I'm glad to be here.
I am I am happy to have you, so thank you for that. Uh, while we're going to get into more of problems that people can have, let's just start out with the very basics in case somebody is listening to their very first podcast or YouTube about why they should even have a trust. So could you start out at a very basic level, like who in California should have a trust and why?
So I think everybody needs to remember that a trust is just part of a full comprehensive estate plan, one of the components. And I always say a family or a couple or an individual should have a trust when they have minor kids for sure. And minor, I don't mean 18 or under. I mean anyone who might not do well if they inherited 500,000 or $1 million on birthday number, whatever. So since people's frontal lobes are not fully developed until 28 to 30 plus, I say if you have adult kids or grandkids or relatives, friends, anyone you would want to leave to, who might not do well with that level of money as an inheritance. You should have a trust so you can sprinkle it over time. Clearly, anyone who has a beneficiary who's a special needs friend or family member who might be on public benefits, that person should also have a special needs trust so that there's no interference in the government benefits that people have worked so hard to get established for that person. And then if you have just overall assets that would trigger probate, then definitely you need a trust to avoid probate. So I think those are the big picture items. Obviously, if you have an estate tax, an estate that would trigger estate tax, then you need really advanced planning. But for everyday people, I think the reasons that I listed are the main reasons to have a trust.
And does that only apply to people that own a house or own real estate, or even if somebody doesn't own real estate and fits into what you just mentioned?
I think anyone, whether you own real estate or not, but also specifically real estate. And then the one thing that I didn't add is if you have a complicated family dynamic or blended family, right, then you need it. And really the only people who do not have the potential for a complicated family dynamic are people like me, where I'm an only child, right? I have nobody to fight with ever, no matter what. Even if you think, oh, I have two kids and they're best friends, right? We've all heard stories where that dynamic has gotten tricky. Mostly, honestly, I believe because the estate planning lawyer screwed up and didn't ask enough questions and
Mhm.
didn't plan in enough detail, and didn't communicate things appropriately to each of the kids. So I think there are different reasons that our planning can really create a problem or exacerbate a problem.
I apologize for making a face when you said family dynamic, because I'm like, oh, when does that ever happen? And I'm like, I think you're like spot on. If you have no children or one child, it's pretty clear you're not going to probably have a lot of fighting there.
Right.
When I first started concentrating more in the inheritance space,
Mhm.
and there was like the siblings were arguing and they had attorneys. I'm like, wow, that's so sad. I can't believe this would ever happen. And then the second one, same thing. And the third one, and then I don't know how many down the road where everybody held hands and got along. I'm like, well, oh, so that's the unusual one.
That's the
It's,
anomaly.
it's
Exactly.
crazy. It's
Yeah.
crazy.
Yeah, for sure.
Okay. Um, I've heard a number, and I'm sure there's no number to reference, but I've heard roughly 30% of people that 30% of people that should have trusts actually have trusts. Have
Oh,
you heard any?
I would, I would, I would say it's worse than that.
Oh,
And here's
oh,
why.
oh.
Because I would add, like when we talk about physicians and their oath to preserve life, the word that's not there is preserve quality of life, right? And all of us as the patient think of quality of life. Same thing in the estate planning world. So yes, maybe 30% of the people have a trust, but when you dig a little deeper to see is it going to honor your wishes, avoid court, and maintain family harmony, I would say hardly any of those people, even those who have trusts already, have a trust that will achieve those goals. So I would say it's a way smaller percentage than that.
I've never heard anybody say it that way. Wow.
Which is sad because when we
Wow.
think about a successful estate plan, it should definitely honor your wishes. For sure, it should avoid court, right? And then we hope it maintains harmony. And yet, of all the plans we review, I think in the last 6 years, there's been maybe one, maybe two plans that would do those things of the hundreds that we've reviewed. So that leads me to believe that our definition that I just described is also an anomaly in the industry because it's not meant to do those things. I don't know what it's meant to do, but not that. Otherwise, we wouldn't be seeing all of these deficient plans.
Trying to take that in. Wow.
I can give you an example from today.
Please.
So I met with one of our new clients who had her estate plan done for many, many years. The most recent one was done in 2016. So not terribly long ago, but not, in the last few years. And as we got into it, we realized her husband, who has lost mental capacity due to Alzheimer's, there's no power of attorney for him. There's no power of attorney for her. There's no advance directive for him that she can find, and hers is a very anemic one. The trust was created. There are no actual beneficiaries of the trust. So it's determined through, I don't even know how to say this because it's a technicality, but the surviving spouse has a power of appointment to, after the other spouse dies, determine who the beneficiaries are. So now look at our situation today. He doesn't have capacity, so he can't ever do that. If she died first, there are no beneficiaries. It's going to go to next of kin. That through court. That's it. If he dies first, then she has the ability, assuming that she is alive and has capacity, right? She has the ability to name who the beneficiaries are. But the trust itself does not name beneficiaries. So it's a disaster, right? And on top of that, of the, 15 plus $1 million estate that this is, very little is in the name of the trust. So when people look, and this is universal, when people look at their own trust that their lawyer created, the last page will say it's a Schedule A or Schedule B or Schedule C. So those are the schedules of what are the assets that the people have, right? If it's just one person or a couple, it's just going to be one schedule. If there's separate property, community property, there could be three. So let's just say on yours, right? And I'm just making this up, Jeff. On yours, it says you have a house, right? And you have some bank accounts, and the schedule lays out all of these assets you have. So you look at your trust and you're like, yeah, I got that retirement account, I have that bank account. Great, the trust owns all of that stuff. Well, that's not what the schedule means at all. The schedule only lists what your assets are as a snapshot of when your trust was created. So the client walks away thinking, I'm done. But in reality, if those deeds weren't re-recorded into the name of the trust, if beneficiaries weren't added as the trust is the beneficiary, right? If joint investment accounts, right, or your own investment account wasn't changed so the owner is you as is the trust with you as trustee, then it's just a list of assets. When you die, we got to go to court to pull them all into the trust. And either that's a mini court process, or it's a full probate, depending upon the situation. So we don't ever do schedules because it leads a client to believe that their trust is funded, which was the case in this case, right? Where the rental property was in the trust, but it doesn't look like anything else is. And it's like 15 plus million dollars worth of assets. So it's really important, right, that this be done comprehensively and detailed.
I don't even know what to say. I mean, that's so in this case, if something happens to her, the husband has, I mean, I don't even know what the husband has because he's incapacitated.
So the worst part is if she dies first, all of her that he has no living relatives that we know of, right? So if she dies first and then he dies and then it goes to his living relatives, it's going to be some random cousin he's probably never met, or it's going to go to the state of California if we can't find that relative.
If she passes first, how does this guy get taken care of? How does he get care? How does he have somebody that
It's
says this is what?
terrible. It's terrible. There's nobody in line to do
Wow,
that.
my goodness.
And so because this wasn't an ongoing relationship where every few years the lawyer connects with the client, this this lapsed, right? This opportunity while he still had capacity lapsed
Right.
so that that could be fixed. And now, we normally we go to court and we're like, we can get this solved. But recently we had a case where it was clear cut in our minds of what was going to happen, and the judge disagreed. And it's outrageous what this judge did. And that's just it. We're just stuck with the judge's opinion unless they want to appeal. And so now we're nervous. Like, what if you get the judge who's not very bright about this, right? And not sensible about this. And so just today, when we were talking about the client I just mentioned, Din and I were strategizing, like, how can we get around this and work on this without going to court? Because what if we get that judge?
Right.
So you don't want to leave anything to some judge who doesn't know you and doesn't care about you. You want to get this done the right way the first time or second time, or at least before you lose capacity or die.
So who in California should have a trust? Oh my, so that answers that question. I am dumb. If you would have said, and this is why you shouldn't use LegalZoom, I'd say, okay. I mean, kind of knew that. I mean, LegalZoom's great. I don't want to get sued for saying that. But you should,
But it has its limitations.
my opinion is you should have an attorney help with this.
Yeah.
Um, However, an attorney helped her with that.
Oh, yeah. We see this all the time, Jeff. Like all the time.
Wow. Okay, I'll stop shaking my head.
Okay.
What, since so few people, let's just say this fantasy number that I had was actually accurate, that
Yeah.
30% of people actually had a good trust. What do you think stops the 70% of people that say, yeah, it's a good idea. I know I should get one, and they don't, or they haven't yet? What have you heard like the common objections?
I have, and I think it's a few reasons. One, they don't think they need it. They don't understand the value of it. Two, the topic sucks, right? No one wants to talk about incapacity and death. And three, they don't know where to start,
Mm,
right? And four, they think it's too expensive. But when you talk about what the fees are if you don't do it, it's a no-brainer to do it, right? Um, and five, I would say they're just kicking the can down the road, right? They're like, yeah, 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 I know I need to do it, but I am not there yet. I mean, we have clients, we just got a call today from a woman who said that her dad is 98 years old. He has no estate planning. He's now on palliative care. He's married to a woman who is a monster. and won't let anyone have access to him or tell anyone what his assets are, right? Like, don't wait till you're in that situation. It's so sad. So it doesn't matter if you're 35 or 95, right? It's time to kind of address these issues. And there are so many people, and I know that my personality is probably not the norm in the lawyer world because I'm friendly and I smile and I have fun with people. I'm also very serious when I need to be.
Yeah.
But you can find someone out there you connect with, you resonate with, so that you can have these types of conversations. And I end my planning meetings, which are 2 to 3 hours usually. And I end these meetings with so often people saying, "Oh my God, that was kind of fun. Like I don't really want to hang up now, right? From the Zoom or walk out the door in the office." So you can find people you connect to and the peace of mind you get when this is all done is immeasurable.
Yeah, you were taking me back
Does
to
that
back in the day when I was actively knocking on doors and how I passed along some information randomly to somebody that answered the door. It was very rare when I would say to somebody, "Do you have your home in a trust?" I mean, it would need to be, I knocked, they were happy to see me, and we spoke for a while, and it felt like it was okay for me to say it. So it wasn't a common occurrence. I asked this gentleman, he goes,
right?
"I don't need to take care of it. I just added my son to title." Like, wow, that's such a bad idea. I mean, I didn't say it. I'm like, okay. And I'm what's such a bad idea? Anyway,
Yeah.
it's like you were saying, the
On
people
many
that,
levels.
or even the people that say, "Oh, the was it death on transfer? What's that one called?"
A transfer on death. Yeah,
I'm
transfer on
sorry,
death. Let's go
transfer.
back very briefly to what you just said because it's so important and people don't realize it, right? I don't blame them. I always tell people, like, this is my area. I know it really well, but I promise you, you do things for work that you know really well that I don't know, right? So this is just an exchange of information. So when you add your kid to the title, let's just say you bought the house a long time ago, right? Most people who are adding their kids to the title, let's say you bought it 30 years ago. And let's say you paid $100,000 for this house, and now it's worth $1 million. So if you give it at your death to your son, then he gets to step up in basis. So then he goes to sell the house, and all is good because it's now worth $1 million at date of death. He sells it for $1 million. That's great. But when you add him during life, you give him your initial basis of that 100,000, right? So then he goes to sell it after you're gone, and he's paying capital gains on 900,000. So from that perspective, it's terrible. But it's also terrible because if that adult son gets in a car accident and hurts someone, that PI attorney is doing a search for every asset that that guy owns. He's going to find that house. It doesn't matter if it was dad's, it has his name on it. So he can get it in a lawsuit. That's not what that dad expected at all, right? So there are other reasons why you should never do that other than just taxes.
Thank you for that explanation. Um, what when you're being visited by somebody that had a trust created by another attorney, what are common errors you see uh, when people are updating their trust? And so common errors or just things that needed to be updated that weren't included the first time. Does anything stand out?
So only in the trust, I would say they have the wrong trustees or they have co-trustees, which some financial institutions aren't accepting anymore. That's a
Really?
problem.
Wow,
Yep.
I didn't know that. Okay.
Same with the power of attorney, right? You cannot have co-trust. We don't recommend co-trustees. So that's a problem. But you can also have the wrong people, right? People like I was asking this client today, who would you want to be the trustee? And she said, this particular family member, and I said, but is he accustomed to real estate and having to sell it and these large accounts and what to do with them and all the charities and navigating, calling to talk to the person who has authority to sign off on an accounting and like and that gave her pause, right? Because not everyone is able to do that kind of stuff. So you have to pick the right people. Obviously, funding the trust, right? You want to make sure that your assets are properly in the trust. If you have special needs folks and they don't have their own special needs trust, or your trust doesn't birth a special needs trust, that's a big problem. And so I think that also within the trust administration, you want to hire a lawyer because you want to make sure that it's done properly from beginning to end so that you as trustee are relieved of any liability in the proper amount of time. And I think that you want to make sure that in the trust document itself, it's clear as to who are the beneficiaries and how do these gifts get given. We see some life estates, right? And the life estate says so and so can live in the house forever. And then that's it. Well, who's paying for everything during that time? Who pays for it if a tree falls and the insurance deductible is $10,000? Who pays for all the expenses? What if, like we know in California, real estate, it's really hard to get insurance? What happens if you can't get insurance? Who's responsible for paying, right? So you have to have all the details laid in, and you also have to have in a life estate an account set up that says the trust is paying for this. Or if there's no money, that's fine. Then you have to say if these things don't happen, like insurance and you can't pay property tax, you have the ability to evict them, right? So that it's the powers are in the trust. There's also mandatory splits that still we see trusts today have. So a couple comes in, they have a trust together. When the first spouse dies, the trust splits into two parts. The decedent's share as half, I'm simplifying it, and the survivor's share as half. Well, the decedent's share is half. Now we have to do a trust administration. We have to get valuations and appraisals. We have to separate the assets into this. We have to get an EIN, a tax ID number. It pays its own taxes. And the survivor, depending upon how it's written, may or may not be able to access that money until her share. We always kill the guy first because we're a women-owned firm. Until her
No
share,
offense taken.
no offense, no offense intended, until her share is exhausted. Well, that could be a disaster, right? And then you have blended families where they're like, yeah, I want that AB split because I don't want my kid, the stepmom is the survivor. I don't, but then who's the trustee of that decedent's share? Stepmom. So could stepmom just say, I've exhausted my share and now I'm going to access everything in my dead husband's and pull it all? Like, where are the checks and balances? Well, you can't have his kids be the trustee because then they're never going to give anything to stepmom. So, but almost every trust we see, stepmom is the trustee or the kid is the trustee, and that doesn't solve the problem, right? But think of it in your situation. If there's no blended family, right? So you would want everything, my guess is, you would want everything to go to each other should something happen to the first of you alone.
Yes.
What if this mandatory AB split is there? Because the lawyer just did it because that's the way it's always done. You wouldn't think that. You would think, oh, everything's going to me as a survivor. And I can't tell you, probably 80+% of the time, it's a mandatory AB split and the client has no idea. The lawyer didn't even talk about it.
So the lawyer just put it in because that's how it
Well,
was done in the old days.
normal. Yep.
Wow.
And the client is like, what are you talking about? I have to do trust administration now. And depends what the assets are. What if it's only a house and now we have to put half in an irrevocable trust? And now the mortgage company calls the loan. You can't put a house in an irrevocable trust unless you're the Gettys, right? So it's a mess. I mean, there's other things that I will say should be in there, but those are just a few.
Holy cow. Wow. Well, if somebody's listening and doesn't have a trust yet, please hit the pause button and call Rebecca. Make an appointment. Wow. Oh, I mean, I can't, you just mentioned so many things. Wow. All right, I'll stop saying wow. Uh, so a global word for what you do is estate planning.
Mhm.
And we were speaking about just before we hit the record button. How do you recommend your clients plan? How do you help your clients plan when there could be something we spoke about Medi-Cal can be changing? So without getting into the weeds of what's happening with Medi-Cal, but knowing that that might be changing, knowing that the estate tax exemption may be changing. Whenever there's whispers, oh, in January of next year,
Right,
this may
right,
be happening, but somebody's sitting in your office and you're doing or on the phone and you're doing the planning, so they want to get something signed months and months before what may or may not ever happen. How do you
right.
advise your clients in that situation?
So it's tricky. We always joke that we don't have a crystal ball, but if we did, we'd be so good at our jobs. Right? Whatever the law is now, even if nothing is changing, even if it's several years ago when then nothing it was in the news, right? You still don't know what the law is going to be when you die because you don't know when that is. That could be 25 years from now. I have no idea what the law is going to be in 25 years. So the only way that you can be somewhat protected from those is you find a lawyer you feel really comfortable with who has lifelong relationships with their clients, right? Most estate planning lawyers, and this is a question I do presentations all the time for different groups. And so I say, fine, and I have a list of questions that I say, these are the questions I would ask if I were looking for a lawyer. And one of them is, do you view this as a one-time transaction or an ongoing relationship? Right? These documents should be reviewed every few years and maybe more often if you have a life change. A life change is a divorce, a death, a marriage, a new child, a new grandchild, right? Or anyone in your plan where you're like, I don't want them involved anymore, right? Any kind of severing of relationships, you have to look at your estate plan because probably they're named in, if they were close to you, they're named in there. And so the only way to do this is to have ongoing relationship with your lawyer and be comfortable that you can call anytime and ask questions, right? That you're not billed for every second you're on the phone and that you can really develop that trust and friendship really at some level with your attorney.
That is such a perfect answer. And I know I didn't like set you up to answer it that way, though. God, but you need your clients also to take charge, right? I mean, yeah, you could set up a tickler to make sure to call everybody every year, whatever it is. But the person that creates the trust with you, they need to take ownership of it too.
We collaborate together, right?
Yeah.
And we do. We've figured out the sweet spot is every 5 years. So we send out these maintenance letters every 5 years. And then when they don't respond to the letter, all they have to do is say, yes, I think I might have changes. Yes, I think I want to review this with you, or no, I'm good, right? But for all those people who don't respond, then we follow up with an email, and then we follow up with a phone call, and then we follow up with a text. There are still people who don't respond, right? And I just hope for those people, nothing's changed. But I think it's the reminder of us as the lawyer reaching out because life just keeps on happening. I mean, just think of, since the pandemic started, how many things have changed in people's lives on so many layers. So I think clients should rely on their lawyer to some extent to be that tickler, but then you got to jump on it as the client and be like, "Oh, that's my reminder."
All right. Awesome.
And so many people die unexpectedly. I hate to be so morose about it, but it's true. And in the last 3 weeks, we've had 8 clients die. We have never had that many clients die before.
Wow. Oh, I'm so
So
sorry.
it's
Wow.
terrible and devastating,
Wow.
obviously.
And that's why people need to plan. I hate to say it that way, but that's the bottom line.
Yeah.
This might be actually, in a weird way, a good segue. I
Okay.
don't think I've ever thought about it that way. So, because I'm going to ask you a question about trust administration. So now the last person has passed, and now the trust needs to be administered. The last person's life, if there were two people involved in the trust, their life needs to be wound down. The trust needs to be unwound according to what the trust documents say. What are the biggest issues you see with trustees during a trust administration?
Definitely first the wrong trustees, right? Somebody who's delinquent in their duties, someone who is doing shady things, two co-trustees who don't see eye to eye, right? I have two trust administrations right now. And what do you do when you can't get the other person to act? You have to go to court. You have to try to remove them as trustee. You have to or resign and let nothing happen, and you're never going to see your inheritance. Or if you force the trustee to resign through a court order, you're never going to talk to that person again, right? They're never going to talk to you again when you
Right.
took court.
Yeah.
So co-trustees are just a bad situation from the beginning. I would say people who don't hire lawyers and think they can do this on their own, it's also a bad idea. I mentioned that earlier. It's so important that these 120-day notices go out, that we capture all the assets, that we use, the pour over will to put them, in the trust, that we find all the assets. Most lawyers are not creating an asset sheet, right? It's like that beginning part where we talked about the schedule. Well, that was your schedule back in 1999, but now you have totally different assets. So if you're not maintaining that asset sheet to keep it up to date, sometimes we have to hire a private investigator, right?
Assets.
Everyone should be sure that they search unclaimed property in California. By the way, do it even while you're alive, or do it for anybody who's passed.
What's
So
that called?
so search online for California unclaimed property, and you'll fill out your name, parents' names, siblings' names, friends' names, spouses' names. California has $8 billion in this account that is
Wow.
unclaimed property. And do it every few years because things will just pop up.
Wow.
Um, I think that trustees also need to do a really good job to communicate with beneficiaries. And I think I hate to say it, but there's like how most people do a trust administration and then how I do it. And I do it even differently than my law partner does. Because she's usually dealing with the court side of things, where things are very formal and structured, right? But I'm doing a trust administration right now, and dad died, and stepdaughter is the one in charge of everything. And trusts, it was this AB split with her mom, who died a long time ago. So there's this irrevocable part that we could never fix. And there are four beneficiaries. There's also three different trusts. So there are four benefits, it's a larger estate. There's four beneficiaries, three siblings, and this woman's brother. She doesn't have the best relationship with them all, right? And so I don't want them hiring lawyers because then that just eats up money that should go to the beneficiaries that the people who created the trust worked so hard for. It should not be wasted on lawyers. So I reach out to every beneficiary. I did it this just today. I reach out to every beneficiary and I introduce myself. And I say, I would love to set up a call. First of all, I'm so sorry that your loved one passed away. And I would love to set up a call where I can, without breaching my attorney-client privilege, which is solely to the trustee, I want to answer your questions about the procedure of trust administration. I want to be your go-to person if you have questions, because most people just want to know what the hell's going on and why is it taking so long. And so when the lawyer just sends out the 120-day notice that says you have a trust administration has begun and you have 120 days to contest, there's no context of what does this mean? I got this package from a lawyer and it scares me and it's uncertain and nobody wants to get mail from a lawyer, right? That's terrible. So I just forewarn them, this is coming. Let me tell you what it means, right? Obviously, if you need to hire your own attorney for any reason, you should, but I can answer procedural questions and I can keep you abreast of the status and I can give you a realistic timeline for how long this will take. And I save a lot of people from tension, let alone potentially some litigation because they just feel like they're a part of it. So you want to hire a lawyer for sure. And I have people where they don't want to talk to the beneficiaries. So I can be the go-to person for them, right? And that helps. Um, Obviously, I think if you pick the wrong trustee who's greedy or doesn't want to honor their wishes or is trying to bifurcate the trust, that can be messy. Um, and then on the administration side, when things are messily, you know, ambiguously written, it makes it hard to do a trust administration. And Din is doing one right now where the client already lost capacity, so we had to do a conservatorship, and now he died. And he had all these interlineations, which are handwritten notes all over the trust. By the way, anybody who's watching this, don't do that. You can do it on a copy, but do not do it on the original.
Exactly.
Basically, it's like this person no longer gets 10%, they get 5%. This person now gets 18%. Every single one has changed numbers.
That doesn't hold up under law. Okay. Because
So
they didn't
now
know who wrote it. Okay.
so
Okay.
now Din is like, well, even if we assume he wrote it, which which one are we following? Did right? Because everyone is going to argue, I get the higher percent, whether it's the old number or the new number, which isn't going to equal 100. And so she's like, screw it. I am not going to even start this. We're just going to court and I'm going to get the judge to interpret it and decide how it should be. Right? So
Yeah.
when things are ambiguous, we have to rely on court sometimes, and that's expensive. We don't want to do that if we can help it.
I was about to say, wow, and I'm going to restrain myself, even though I kind of just did. It was like such an amazing answer of why somebody shouldn't. I mean, somebody could be saying, well, she's saying to hire an attorney to administer the trust because she's an attorney, she's going to make money. Though your entire long, long, detailed answer are the reasons why. And I think people don't understand also, they need to understand what probate code is in order to administer the trust properly.
Specifically for that initial part where you have to give notice, right? So
Right.
if you give notice, then after the 120 days, that beneficiary is barred from suing and contesting the trust. So I didn't even talk about the examples of people who dole out distributions before the 120 days, right? Now they
Please,
have money to hire a lawyer.
please share one so people can get a sense of, wow, this can happen.
So within that 120 days, you don't want to give any money out no matter what to any beneficiary because the person who's like, ooh, I want to contest, but they don't have any money to hire the lawyer, now you just gave them money to hire the lawyer. On the other side of the 120 days, we then have to do an accounting. Unless it's like me, where I'm the only child, right? Who cares if I'm the trustee and the only beneficiary? I don't need an accounting. But in most trusts, people are going to want either a simple accounting or more complicated, more detailed accounting. And so you don't want to give money before they've signed off on the accounting because that accounting is going to include your fees as trustee. It's going to include a reserve to pay for those property tax supplements that you might get 2 years from now in LA County, right? Ventura is probably a little better because it's smaller. Or you have taxes that are due a year and a half later, depending upon when somebody dies, right? So you want to make sure that you have a reserve for that. And so many people will start distributing money and then, oh my God, there's a reassessment. Where are you getting that money? You think you're going to claw it back from all these beneficiaries? It's coming out of your pocket.
I was just
So
going to say, that like legally can only come from the trustee. If the beneficiary
Right.
say I don't want to,
The
the
trustee is
trustees on.
responsible for that. And the IRS can go after the trustee if you don't pay the taxes, can go after you personally. So you have to wait for the green light from the lawyer saying, now's the time. You can give money now.
Wow. Oh God, I said it again. Okay. My goodness. I didn't realize I keep on saying that. What are what family dynamics do you come across that are more common that create issues with either creating a trust or administering a trust?
On the when everything's fine client, right? The younger clients, no disabilities of any kind, physically or mentally. There's then it's really a messy family dynamic, right? Where you could be unduly influenced. But on the elder law side, there could be coercion, there could be fraud plus undue influence. And so you want to make sure, there's like on the elder law side, people don't realize this, but on the elder law side, many people will want to leave their something to the person who was their caregiver, right? Because they might have been their closest person to them. And so they update it. So because there's so much undue influence by caregivers, right, by the nature of their relationship, even if they haven't done something really nasty, those gifts to caregivers are presumed invalid 100%. The only way you can rebut that presumption to get around that presumption is you get a certificate of independent review from another lawyer, not the drafting lawyer, who interviews that person to say, do you really want to do this? Or is there any undue influence? Is it really clean and there's nothing shady, right? With that certificate of independent review, you can do that. So I think the hardest part is messy family dynamics. I mean, one of my favorite stories is wife died a long time ago. Husband was elderly. He had a caregiver. There was a daughter. He ended up marrying the caregiver. So there's different levels of capacity that you need for certain things. To create an advance directive and power of attorney is the highest level contract capacity. The law is really clear for a simple trust or a will that you need testamentary capacity. For a more complicated trust, it's meaning you know who you are, what your stuff is, and who you want to give it to. A complicated trust, even one like you have or I have, so I don't mean it doesn't have to be you're a zillionaire. It's somewhere in between the mental capacity of contract capacity and testamentary capacity. Then you go lower and it's like, oh, the capacity to divorce, you just have to say consistently throughout the proceeding, I want a divorce. I want a divorce. You could not know who the president is. You could not, it doesn't matter. I just want a divorce. But the definition for capacity to marry is just one time, I want to get married. Yep.
I
That's all you
do.
have to say. I do.
Wow.
Nothing else. You don't even know your name. You don't know, right?
Oh,
Nothing. So
so that's
this,
very interesting when it comes into estate planning.
right, right. It comes up, capacity comes up all the time.
Hmm.
So this man married the caregiver. He had no idea what he was doing. He had nothing. And she got the record sealed. I don't know how she did that because I'm not a family lawyer, but she got the marriage record sealed. So they were confidential. So we essentially she came to our office, this caregiver, and we had an envelope with cash. And we were like, I'll tell you what the deal is. I forget her name. I tell you what the deal is. You either take this envelope of cash or we're reporting you to the DA and the police for elder abuse. And let me tell you that the longest time you can go to jail is 4 years. So that is your deal. Take that one or the envelope with the cash. What do you think she chose
I'm going to go with the cash.
with the cash? Right? But it's messy.
You'll have to apologize. I just had a vision of Monty Hall and somebody wearing a costume, and they said, "Well, you can take door number one or door number two. Door number two, if it doesn't work out, you're in jail for 4 years. What's your choice?"
Exactly.
Wow.
We
What,
do
so
have some entertaining stories.
when does your book come out? Incredible. So in your practice, it sounds, would it be wrong to say Den does more probate work? Because you said
She
she
does
does more,
all the probate. Yeah,
all
anything
the,
related
okay,
to court, she does. I never, that was our
okay,
deal. She had to do
okay.
court, and I would do anything and everything else.
You got off good on that one. Uh, so I had a question, and maybe it's more for Den. I was going to ask, like, if someone is administering a probate, is
Mhm.
there i- is there certain advice that you or she would give them, or is it, look, this is just by the court, so here's A, B, C, D, E, F, and this is what you have to do?
Right, right, right. So I've asked her this question before, so I'm prepared. She said, for sure, hire, and I'm going to read some of my notes. For sure, hire a lawyer. Because what happens when you don't know the system is the case just continually gets continued. So what should take a year or two could take like 4 years just because you don't know how to manage the case appropriately. And so for sure, she said hire a lawyer. She said keep track of all the money and don't ever pay cash for anything, right? So you want to make sure that all of your accounting and what you've paid for and all of that is clear. Um, she also said, avoid it, get your trust done and fund it properly, right? So that that isn't an issue. And then she has this story. And of course, I wasn't involved in this because this was Din. So I'm just going to read you the
Please.
caption notes. She said, a guy died, this guy died in a fire. He didn't have an estate plan. A public administrator was called in because no one could find his family. Then too many family, because then there's a public notice to everyone. Then too many family members were found, and there was a fight over who would be the administrator, the executor, right? The one who administers it. One of them was a niece who was adopted away from the family as an infant and was fighting. One of them was our client, who was the first cousin. Then there are second to third degree family members who were represented by the public administrator. When we got appointed, we found out someone had forged the records using a stolen notary supply, a stamp, right, to transfer the property to himself right after the guy died in the fire. Then there were squatters in the house, which was mostly burned down. Then there was a contest as to who the heirs were, and we kept finding new assets. Like they would just like it was just a treasure hunt, a scavenger hunt for assets. And the probate took about 4 years to complete.
There has to be somebody listening that says, you've got to be kidding, you just made that all up. Can't happen.
Oh, there's stories similar to where we had to determine if a marriage in India was legitimate or not, and somebody had gone there to forge the records in India to make it look like it was real, but it wasn't, so she wasn't considered a wife. These things get
That's,
crazy.
I had one recently where, let's say it was 2020. So there's three brothers. One of them was the trustee. Mom's alive. They wanted to take her house out of the trust for Medi-Cal, Medicare. I'm probably not getting it exactly right, but trying to move assets. Then let's say 2022, she wanted a different son to be trustee, so signed, the the former trustee signed a document, the new trustee signed, the mom signed, and everything's filed. Mom dies, and the former trustee brother says, I want to be the trustee again, just files a new deed, and the judge looked at it and said, yeah, this looks like a good deed. Like, oh, I didn't realize that was possible. And when I tell people that, they said, how could that happen? I'm like, well, the court or not the court, the county recorder
Yeah.
gets the deed, looks at it, and goes, yeah, this is filled out right. We'll file it.
Right. They are never looking to see what's legal or legitimate. It's just does this deed comply? Now, depending upon things, how you do it, property might get reassessed. But
Right.
they're just saying, oh yeah, this is a valid deed.
Exactly. Exactly. I have a question that is more personal to my practice, and
Okay.
just curious. There's no right or wrong. So, part of my practice when somebody inherits a house is to help them figure out the actual as is price when
Mhm.
they're thinking of selling it. Instead of guessing at the as is price, putting the house on the market, preferably at a lower price than we think it'll sell for, to purposely induce multiple offers to drive the price up to get like a offer that they could sign if they wanted. That to me is like the true as is price as opposed to me guessing because I would have got it wrong every single time if I would have guessed.
Mhm.
So if somebody comes to you as the trustee, they're administering a trust and they say, I just spoke to this guy. They don't say my name, so you're not swayed either way. Uh, do you feel is there more risk to the trustee in just selling as is and not seeing if they could have made more money renovating the property? Do you see more risk if they choose to renovate? Like, yes, they could make more money, but so many things could happen that could go wrong that they're better off selling as is. Do you have feelings either way on that?
So a few things come to mind. One, it depends who the beneficiaries are, right? Am I the trustee and the only beneficiary? Then I'm gonna do whatever I want, right? Am I accountable as trustee to all these other beneficiaries? Then I must act as a prudent investor would and get the most I possibly can. However, exactly what you just said, what if you then sell it to someone who's litigious, right? And they uncut, like say you tried to fix it up, or say there was mold and you tried to cover it up, or water damage and you tried to cover it up, or in this case with all these fires, God knows what this will be when those houses get sold that didn't burn down, right? So is there potential liability or can't, Pandora's box that you open by fixing it up? Absolutely. And you need to be mindful that that could happen. But it also depends on, are you selling it right when the person died? So that that is your basis and right. So like say you died last month and this month you're selling it, probably you don't need a formal appraisal as of date of death. But if you've waited some time, you need that formal appraisal as of date of death anyway. I always recommend getting an appraiser and not using realtors, but a lot of people use realtors. I just feel like if you're ever audited in the whole world of being audited, right, then don't you want the most reputable thing you can so that 3 years down the road, you're not like, oh God, now how do I figure this out and justify it? So I think that having that formal appraisal gives you some idea as to what the value will be as is. That doesn't address the issue of should you do more. Also, some people are like, they love these sorts of projects and they're really good at it, right? And they might have some contractors or subs they like. And with a little bit of work, you know what curb appeal can do, right? With a little bit of work, you really can get a lot more. And other people are terrible at this, and it's going to cause them anxiety and distress, stress, and it's going to take a year longer, right? So you have to look and have an honest look in the mirror and say, what kind of trustee am I? Right? Could I take this on to do some basic fix it, or is that a terrible idea for me? So I think it's kind of case specific
Okay,
and
awesome.
rely on the realtor. The realtor in your expertise is going to say, if you do some paint and some lawn and, some quick cabinetry work in the kitchens and the bathroom, you're going to get so much more money for a fairly small investment.
Hmm. Thank you.
Yeah.
Thank you. I think we can put a bow on this with one more probably set of questions.
Okay.
You have an expertise in special needs trusts.
So we have to be careful to say
Okay.
about expertise and specialists. So there
Okay.
are certified specialists in estate planning, Din, my law partner, is a certified specialist. There isn't an actual certified specialist for special needs planning, but we do
Okay.
it a
Okay.
lot.
Okay.
Okay,
Thank you for clarifying.
sure.
What different issues do people need to be concerned with when they have a special needs uh, member of the family or somebody that has special needs that they want to take care of in their trust that we haven't already covered with a traditional trust, if that's the right way to say it?
So special needs trust, I'll just give kind of the big picture for a few sentences. So you either special needs trusts or supplemental needs trusts are specific for those people who are on public benefits or will be on public benefits. And so you can have assets held in this special needs trust and not disqualify the person from their benefits. So as a result, probably this person is going to have special needs for a long time. So you have two choices. You can either, in your regular trust, create a special needs trust that is birthed at your death from your trust, or you create a standalone special needs trust that is specific to this person. People can put money in it during everybody's lifetime, or at your death, your assets for that person can funnel into that trust. If you have just one kid who's the special needs kid, let's say, you might be able to do it the first way, where your trust births a special needs trust. If you have multiple kids or multiple beneficiaries, and just part of it is going into the special needs trust, it's probably wiser to have a standalone special needs trust. It means other people can put money into it, right? And it's a vehicle to hold that money. But also in the trust administration process, the Social Security Administration only has their eyes on that special needs trust and not the family trust. Otherwise, they get to know all your business and it creates a more complicated trust administration. But in terms of the special needs trust, I just want to give that background so people kind of
Thank you. No,
understood.
that's perfect. Thank you.
Okay. Um, but in terms of what you should include, I would say you need long-term trustees. You need backups, right? You need people who can do this for a long time. If they can't do it, you need another person and another person. At minimum, you need a mechanism in the trust of a way, hopefully, to appoint a trustee that doesn't require court. So I think it's hard for a lot of families where they have a special needs kid who's going to be with them. Like we have a client right now, and in his later year, well, the parents are in their 80s and 90s, and the kid is in his 50s. And about 10 to 15 years ago, he was diagnosed with schizophrenia. And so he can't be he's their only child. He can't be the trustee, right? So we don't serve as trustee very often, but in this case, it's a really complicated estate. And so we said we'll serve in this capacity as trustee. So I hope fast forward when they pass away that I am not regretting this decision. But I think it's important to pick people who know how to do it, or you just have the backups of how to appoint someone if that first person can't do it.
And that sounds like a really big challenge, having the backup, because you
It
could be
can be.
talking somebody 20, 30 years down the road.
Mhm. And so the problem with a standalone special needs trust is it is irrevocable, right? When you create it today,
Ir
it's irrevocable.
irrevocable. So
So
meaning
you
you cannot make any changes to it.
Right. I mean, there are ways through court and through other ways you could change it, but the idea is it's irrevocable versus the trust that your trust births the special needs trust. You could change that whenever you want, as long as you still have capacity.
So when you say it births it, does that mean that the individual, they create their trust, or they have their trust, they create the special needs trust. However, it's not a trust, if I'm saying it right, yet. It's
Until
here.
they die.
When I die, then it is, then that's when
It's
it
just on
becomes
paper
irrevocable.
that Yeah, it's just on paper. So let's just say you had two kids and one of them, because I'm not going to pick your daughter, one of them was special needs, right? Then at your death, let's say your trust would then birth that special needs trust for that kid. Right now, it's just on paper what it says, but it can't hold any assets.
So the benefit is that you can tweak it along the way as long as you have capacity and
Right,
life.
right. Yeah,
And then you would have a mechanism of how it gets funded in your trust. So
right,
when you pass and that gets birthed, there's a mechanism that says these assets get transferred into it.
right.
Got it. Wow. Okay.
Which is the same case if you didn't have, let's say you have two kids and there's no special needs, you're going to say the trust is going to extend on for them after I'm gone. And this kid gets this house, this kid gets this cash. You could still do it that same way, right? Having nothing to do with the special needs. So estate planners do that all the time.
So a question I did not have in mind that you just brought up for me is, so we have one daughter and she's not going to be getting married for a very long time. She's only 10. Is there a mechanism, or what is the mechanism and what should we be doing so her assets are her assets when we pass in case she's married when she inherits everything? Is it automatically separate assets at that
So,
time, or do we need to do anything differently?
so yes, I'm going to say yes. The legal answer is any inheritance during marriage is separate property.
Okay.
However, people unintentionally commingle property all the time. So let's say she inherits a house and she's married and there's a mortgage, right? And she's able to assume the mortgage, get her own mortgage, whatever, and she and her husband live in the house, right? And she takes her income and she's like, I'm going to pay the mortgage, right? It's my separate house because I inherited it from my parents, and I'm going to take my income and pay for it. You're not even going to touch it with your income, right? 50% of every dollar we earn in California when we're married is our spouses. So I use a visual because I'm visual, and I say, like, when we inherit property or bring property to a marriage, it's like a clear bowl of water. It's totally separate property. But as we start paying for the mortgage and all the repairs and the property taxes, we're dropping red food coloring into that. Over a period of time, it is now community property. So the only way to keep it separate is either you also left her this large account and she pays for everything in the house from that account, all separate, or your trust requires her to get a prenup or a postnup. Now, the
Okay.
reason I like that, and that's in mine, is because we administer a lot of trusts and we see these hopefully middle-aged people who have been married for sometimes a short time, sometimes a while, because hopefully the parents die old, right? And they want to say, I want a postnup, but they don't because it will create friction. But if you can blame your dead parents that they made you do it, you're golden.
Wow.
Right? So in ours, you have to have a post. Now, I'm not controlling from the grave. I control from the grave a lot in our trust, but I'm not controlling from the grave to the point where I'm saying this is what you must say in it. But my goal is, along with all my other conditions that I have a lot of, which I'm happy to share with you at some point for your own trust, is it'll give her the education. If she has to get a post nup, right? Because my daughters tend to. If she has to get a post-nup, she has to hire a family lawyer. That family lawyer is going to teach her about separate property and community property as a result of that process. And so for me, it's about education. So if she has a good marriage, she's going to write a post-nup that is fair to her spouse. If she has a rocky marriage, the lawyer's going to say, do it this way, right? And so I'm relying on that education at the time.
This has been so chock full of information. so chock full. I really, really appreciate your time and your expertise, your willingness to share your expertise with me and with our listeners. Thank you.
I'm so happy.
Thank you.
Anytime,
Thank you.
anytime.
Thank
I,
you.
I love teaching people, so I'm happy.
You have taught so much.
Good.
However, before we end, please, you need to let people know how they can get in touch with you.
So we have a website, goldfarblou.com, GOLD, F like Frank, ARB like boy, LUU.com. And it has all our phone numbers and contact page and all that kind of stuff.
Okay. Perfect.
Thank you so much, Jeff. It was fun to hang out.
Likewise. Thank you so much.
All right.
Okay.
Bye.
Bye-bye.